On debate, Senator Kutcher.
Thank you, Mr. Speaker. Honorable Senators, I rise today to speak to Bill S-207, an act to amend the criminal code as it relates to disclosure of information by jurors. In my opinion, this bill addresses an important issue that has not previously received sufficient attention: the mental health of jurors, which can be negatively impacted as an unintended consequence of fulfilling a civic duty. This bill helps address that concern by providing permission for jurors to more freely and confidentially discuss their experience with a health care provider should they need to do so. I applaud this direction and support the bill. Yet, I do not think that it goes far enough to protect jurors. I will share with you why I think that and ask that you consider my comments as this bill is further debated and studied in this chamber and in committee. I must admit that prior to my introduction to Bill 207, I had not paid much attention to the negative impacts that could occur when a juror in some trials must engage with evidence that is highly disturbing and outside their usual experience. That negative impact being the development of a mental illness, post-traumatic stress disorder, often referred to as PTSD. The probability of PTSD occurring, however, can be decreased or the severity of its impact mitigated if a number of economical and relatively easily implemented interventions were put into place during the jury duty experience at federal, provincial, and territorial levels. However, the current structures and processes of jury management is such that jurors are being unnecessarily put at risk while serving in the pursuit of justice. This is, in itself, unjust. In the past, society and legislators may not have considered this issue because we did not know much about it. However, scientific advancements in understanding the causes, prevention, mitigation, and treatment of PTSD are now at the point that as legislators, we can no longer say that we do not know. We now know, and because of that, we must act. Science has taught us that PTSD is a mental illness that can be understood as a failure of the alarm nervous system to extinguish after its activation by a traumatic event. In other words, something happens to some people that makes it extremely difficult, if not impossible, for them to shut off the emotional, cognitive, and behavioral responses to a traumatic event. This is accentuated by the type of trauma experienced, by the individual's genetic makeup, the duration of the experience, the inability to avoid or take control of the situation, and the unavailability of interventions that could mitigate its intensity or even prevent it from occurring in the first place. Risk for developing PTSD includes both genetic and environmental factors, including exposure to previous trauma and current or previous mental illness or substance abuse. Science has also discovered that everyone exposed to a traumatic event will not develop PTSD, but everyone will develop what is called an acute stress response. While this acute stress response can create intense and unpleasant emotional, cognitive, and physical experiences, these experiences will pass with time, and their passing is accelerated and intensity is mitigated by well-known factors. These factors are emotional and cognitive preparation for the event, an understanding of what the acute stress response is, ongoing support from trusted persons, often friends and family, and safety plus security. These factors encourage psychological resilience and promote healing. These are also some of the factors that decrease risk for PTSD and lessen its intensity when it occurs. According to the Canadian Juries Commission, an organization established by jurors whose exposure to trauma-inducing materials during high-profile trials led to the development of PTSD, current jury management systems are not structured in a manner that consider and effectively address these mental health concerns. This conclusion was also reached in a 2018 report from the House Standing Committee on Justice and Human Rights, titled Improving Support for Jurors. Amongst its 11 recommendations, 5 were directed at improving mental health outcomes for jurors exposed to traumatic trial experiences. Honorable Senators, I am sharing this overview of how science understands PTSD and how jurors may be negatively impacted and how they are not assisted in the current process of trauma-inducing trials to underscore why our chamber should support Bill S-207. It is also to draw our attention to how we can go further. Bill 207 opens the door to permit jurors to discuss relevant information in confidence with a duly qualified and ethically bound healthcare provider if the juror is suffering from a mental disorder or problem arising from or related to their trial-based traumatic exposure. This is good, and this is needed. Yet, most of the processes currently ongoing in provincial, territorial, and federal jury management systems that increase the risk for negative mental health outcomes are not addressed in this legislation. And there is much that can be done economically and efficiently to address this concern. For example, jurisdictional jury selection criteria should include history of previous traumatic exposure, mental disorder, or substance abuse as risk factors that could exclude individuals from participating in trials in which traumatizing material will be presented. Jurors who are involved in such trials could have a court-directed and responsible mental health professional available for consultation and ongoing support during the trial and in the period of 6 to 10 weeks immediately following the trial. This is the period where symptoms of an acute stress response may develop into PTSD. Should that happen, jurors can then be immediately referred to PTSD treatment experts, therefore avoiding the delays and long waiting lists that currently characterize access to needed mental health care. Jurors could also be given information about the acute stress response and the symptoms of emerging PTSD and encouraged to discuss any concerns with the court-appointed mental health support person. This mental health literacy will better prepare them for their jury duty and will assist them in identification of need for treatment should that occur. They can also be encouraged to share that information with their partners or family members, as it is often a partner or family member that sees signs of distress, potentially minimized by the person experiencing it. These suggestions are not based on hope and supposition. They are based on what researchers and clinical experts have demonstrated can have a positive impact. They are likely to be helpful and do not require great investment to apply. We are asking citizens to assist our society in applying justice. We have a duty to not put them at unnecessary risk for a mental disorder when they are so engaged. Honorable Senators, I ask that these additional points be considered during committee study of this important piece of legislation. Perhaps the committee may be able to suggest interventions to help federal, provincial, and territorial ministers of justice become better aware of these concerns and even provide suggestions as to how these might be addressed. We in this chamber can urge those who have the power to change the current process of jury management to do so. In doing this, we may be able to decrease the risk for mental disorder and increase the promotion of mental health for citizens whose work as jurors is essential for the provision of justice. Honorable Senators, we can help make that happen. Thank you.
Senator LaBoucan-Benson.
I have a question for the senator.
Okay.
So, Senator, we know that Indigenous people have been historically excluded from jury duty as a result of colonization and colonial bias. Would you not worry that minorities like Indigenous people who have a statistically higher rate of trauma per capita will be further excluded from participating in jury duty if that's one of the tests of their participation?
Senator Kutcher.
Thank you for your very, very excellent question. I was suggesting that that be considered, not that that be prescribed, and that individuals have the option and have the understanding that when they are asked for jury duty, that should they have these challenges and should they have had those experiences, they can request exemption or they can prepare themselves better for what they're going to face.
Senator Duncan, Ontario.
Yes, I have a question.
Yes.
Thank you, and thank you for continuing to bring up this very, very important issue. I do say, as a senator, I have been selected for jury duty for a murder trial, and I can only echo the concerns and the interest in the importance of this issue today. What I'm trying to understand is the cost or the estimated cost to have the right things in place, I believe, before selection, during the trial, and post-trial. Do we have a sense at this moment what this might mean in cost?
Senator Kutcher.
Thank you very much for that question. In my profession of medicine, one always balances the cost of doing something against the cost of not doing something. And I would submit that the cost of doing some minor things, such as having a counselor with mental health expertise available to jurors during this difficult time, would far be less than the cost for the individual, for their family, and then for our society if they do develop the disorder because of the intense impact that it can have.
Senator Deakin, Ontario? No? Senator Simons?
Except another question.
Popular.
As I understand the intention of the bill, it's to allow jurors to seek counseling after a trial. I would be concerned, I'm wondering if you would be concerned about a juror who talked to a counselor in the middle of the trial, that it might influence their perception of the trial evidence. I mean, during the trial in particular, privacy concerns are utmost, but I also worry that just talking through things could color that juror's interpretation of the facts that they're hearing.
Senator Kutcher.
Thank you for that question, an excellent and a vexatious one.
I aim to vex.
You're doing that very well, Senator. I think that the issue here is found in the quality and skill set of the counselor. And those individuals who have had the opportunity to fill parts of those roles or understand those roles that are in this chamber, who are in this chamber, who have been able to seek out and reach out to an individual who has skilled in that area, know that that discussion period, the support, when done properly, should not have an impact on that, in my opinion.